segment, we're going to talk about the best evidence to use at every stage in your claim and appeal. And the idea is that we'd like to help you avoid any unnecessary legwork and frustration in an already confusing and frustrating process.
Yes. Yeah. So in my experience working at the Court of Appeals for Veterans Claims, I receive what we call the record before the agency. And I have to tell you, there are so many times when we're looking at that record, which is thousands of pages long, where you see duplicate opinions, duplicate treatment records, duplicate statements that sort of, for lack of a better word, clutter up the file. And so I think, it's important to remember the VA has a legal duty to assist you in gathering information at the regional office stage. And so when you're filing a claim, if you have copies of VA treatment records, VA is going to get those from VBMS themselves. So you don't need to submit your own VA treatment records. What you want to really focus on is things that VA can't get: private records, lay statements from yourself or your family or your buddies. And so you want to really streamline the process to make sure that you are focusing VA on the most important things in the claim and not sort of resubmitting evidence that VA already has, because you want to make it as easy as possible for VA to grant the claim. And when they're looking through thousands of pages of record and they see the same thing over and over again, their eyes are going to sort of glaze over. And so you just want to make sure that, you're not just sending VA all of your records and hoping that something sticks. You want to think about what VA has and what you can add to that record that VA can't get themselves.
That's right. So let's focus on the most important evidence at every stage to help you connect those dots, make it really easy for VA to follow the story. Mm-hmm. You want to get them to yes, make it easy for them to say yes. And so here's how we're going to do it. So at the initial claim, you're trying to meet all the elements of service connection. So in-service event, diagnosis, and medical nexus. So you want to make sure VA is going to get your service records. And so they should get those on their own. However, sometimes they'll get a letter saying, hey, we can't find everything. If you have anything, send it in to us. Mm-hmm. And that's the point you want to send stuff in. So VA comes back and is like, oh, we have no record of you being a veteran. You have your DD-214, send it on in. Maybe you have some active duty service and VA is trying to get records from the National Guard and they can't find them, but you have those, send them in. But for the most part, they should be able to get your complete service medical and service personnel file. If you have photos, though, that aren't in your service records showing the incident or injury, or that you were at a specific place at a specific time, if it's not clear from the record, send those in. Photographic evidence can be so powerful. This was very powerful for all of our clients in the Thailand era of Vietnam, showing them at the bases, showing them on the perimeter. So if you have photos, old photos, send those in. Lay statements from yourself, from your family, your coworkers, fellow service members. VA doesn't have those. Those you're going to have to submit yourself. So make sure that you send those in. And really what you want at the, again, initial claim phase is for those lay statements to be focusing on the elements of service connection. So again, diagnosis, in-service incident, and a link between the two. It shouldn't just sort of be, I know Mr. Veteran is a stand-up guy, please grant benefits. That should be something that's pushing your claim forward. Mm-hmm. Like you said, medical records from private providers, you can sign a release and VA should get those on their own. But sometimes private doctors are wary about just sending records off. They're not responsive. So if you have your own, you can certainly submit them. And then if you have any independent medical opinion that maybe you purchased yourself or you're working with a representative on that, that provides that nexus information, make sure you're submitting that. You will likely have to go to a VA exam regardless, but it cannot hurt. And in fact, sometimes it's very beneficial to get one of those nexus opinions, especially after you've had the VA exam.
Yeah.
And then finally, be sure that all the elements are mentioned, all the symptoms that are covered in the diagnostic criteria that you have. Don't just list the whole thing, but whatever you have, make sure you're putting that in the lay evidence. That's really helpful for when VA goes to grant benefits and rate you and get you the appropriate rating. After the initial decision, if VA denies, in the decision letter, even when they grant it in the letter, they're going to tell you what they based it on and what evidence was missing. So you want to be sure to respond to that directly when you go ahead and file an appeal.
Yeah. And speaking of filing an appeal, so if you choose to go to the board you have 3 different options for dockets at the board. And choosing that docket is really going to matter depending on whether or not you have evidence. So the first docket is the direct review docket, and the board reviews that case based on just the evidence that has been in the file at the time of the previous decision. So no new evidence can be added at that time. So to your point earlier, if you think that you have submitted all the evidence you've met all the elements of service connection, and you just think that the rating decision made a legal error, maybe direct review docket is the best option for you. But if you think that you still need evidence, maybe you got that rating decision and they said you don't have a diagnosis or there's no nexus, then you want to think about choosing one of the other dockets. So there's the evidence submission docket. And at that stage, you can submit new evidence 90 days within 90 days of filing the notice of disagreement or with the disagreement. And then after that 90 days, the record does close. And then lastly, there's the hearing docket, which a veteran can request a hearing. They can submit testimony during that hearing. They can submit evidence at the hearing. And then again, within 90 days after the hearing. And then 90 days, the docket does close again. So think about it. Talk to your representative about which option makes the most sense for you. But if you do need to submit more evidence, you would want to think about which docket you want to choose.
Right. And so from there, there's a chance that you might need to appeal to the CAVC, the Court of Appeals for Veterans Claims. I think it's difficult to impossible for your average veteran out there to know if that's something they're going to need to do. So preparing for it is not something that you necessarily know, hey, I should prepare for the eventuality I'm going to the CAVC. But maybe you're working with a VSO or with a representative and they have an idea that this is a complicated legal issue. There's a chance we're going up to court. It's critical that everything that you need is in the record before the board makes their decision. And that's because no new evidence can be added at the CAVC stage. That's an appellate stage. The record is closed. The court is only looking at what evidence did VA have before it at the time the Board of Veterans Appeals made their decision. So you can't add anything at that stage. So for what it's worth, if you think that's an eventuality or a possibility, or you want to leave the possibility open, critical to get all that evidence in before the board makes its decision.
And one really exciting thing about the AMA is that the VA, both at the board and the rating decision level, need to make favorable findings.
Right.
And so it's really important to look at both either the board decision or the rating decision to see what evidence VA reviewed and what findings they made about that evidence. So if the RO said that there is a diagnosis or there is an in-service event, maybe tailor the evidence that you're submitting after that to get to the other unmet elements, right? So you can rely on that favorable finding from the RO and say, okay, I know that I have submitted enough evidence to prove that I have a diagnosis, or I know that I have submitted enough evidence to prove that this event happened to me in service. Now I can just focus on the nexus. And so it helps sort of in the process of getting up to the board and up to the court, you're sort of checking the boxes, process of elimination to make sure that you're setting yourself up.
Right. And so there's a couple pieces of additional evidence required for specific claim types. So, just quickly for PTSD, you're going to need stressor verification, whether that be through lay evidence or service records, but VA is going to have to confirm the stressor. For presumptive service connections, we were talking about that earlier with burn pits, but you're going to need time, place, location, and a current diagnosis that meets those presumptive requirements. And then for TDIU, a big benefit on many veterans' minds, VA is going to want your employment records. Your Social Security earnings statement is really helpful there. And then any vocational rehabilitation documents that you might have, or even a vocational expert report that you might have obtained. So some key takeaways really are focus on quality and relevance to what you are doing and not just quantity. Don't throw the kitchen sink at VA and hope for the best. And, it's not to say that this is on veterans to figure out by themselves, because I know it's complicated. So don't stress out too much. Is this relevant? It's going to hurt me. It's not going to hurt you. But make sure you are responding to what's needed. And winning a claim doesn't really require you or VA drowning in paperwork. It's about showing them what they need to get to yes. So when in doubt, you can always work with, like we mentioned, a VSO, an accredited representative, or an accredited attorney. because experience can definitely make a difference here in knowing what evidence and how much evidence to submit as you work through your claim and appeal process.